All right, good morning. All this meeting is called to order. Mr. Truman, has anyone signed up for public comment? Thank you very much. All right, no cases to reconsider under agenda item 3. Is that correct?
That is correct.
Let's consider tax liability cases under agenda item 4. We have 2 tax cases on docket 26 and 1 tax case on docket 27.
For the record, Rhonda Camp, Special Program Appeals. There are 2 tax liability cases on docket 26 and 1 on docket 27. The first case on docket 26 is TD 240140324. Commissioner Esparza.
Agree with the recommendation. Payments to the LLC member are not wages. The company is not a liable employer.
Commissioner Trevino.
I agree with staff's recommendation.
Chairman Daniel.
I agree with staff recommendation.
Thank you. The second case on docket 26 is TD 240170424. Commissioner Esparza.
Agree with the staff recommendations.
Commissioner Trevino
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you. That concludes tax docket 26. And then there's 1 case on docket 27, and that's TD 240100224. Commissioner Esparza,
Agree with the recommendation.
Commissioner Trevino,
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you. All right.
All right, we have no fair housing cases under agenda item 5, no child labor cases under agenda item 6. Under agenda item 7, we have 1 wage claim case on docket 26 and pulled for additional discussion and none on docket 27.
That is correct. We have 1 full wage claim case on docket 26. That is case number 23-053696-1. Commissioner Esparza.
The AT decision is not supportable based upon the current record. There's evidence in the, there is evidence in the file that the claimant may have been subject to an arbitration agreement. That is potentially a jurisdictional issue for TWC regarding the validity of the claim, consistent with the related companies or companion cases, all of which are being remanded for hearings on the arbitration agreement issue. We should do the same in this case. Accordingly, we should hold a rehearing to obtain testimony and documentation from both parties as to whether the claimant was covered by an arbitration agreement that would affect the wage claim.
The employer filed a late appeal to the WCAT decision. Although the employer's appeal alleged non-receipt of the decision, it was unclear whether the allegation was regarding the PWDO determination or the WCAT decision, or they had also previously alleged non-receipt of the PWDO. Based on the employer's contention of non-receipt, a rehearing was scheduled to specifically address the timeliness issue. However, the employer did not appear at the timeliness rehearing. Therefore, the employer has not provided credible and persuasive evidence to rebut the presumption of receipt, and their appeal to the WCAT decision should be dismissed for lack of jurisdiction. Dismiss the employer's WCCA appeal as late.
I concur with Commissioner Esparza.
We will rehear the case. That is the last full case on docket 26. You should have received the short form dissent list for docket 26 and docket 27 for the wage claims.
I move we accept staff recommendations on the remaining wage claim cases on dockets 26 and 27.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 26 and docket 27.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected on wage claim short form dissent lists for dockets 26 and 27.
Motion passes with the exceptions noted. Let's move to agenda item 8, consideration of unemployment insurance cases. Please proceed when you're ready.
Case 3077753, Commissioner Esparza.
The AT decision should be modified. The events in this case took place before the executive order issued on October 11th, 2021. The parties to the case specify that job separation arose from procedures that were implemented due to the pandemic. As such, the claimant should be qualified for benefits. And the employer's account should be protected from chargeback due to disaster. We should therefore modify the AT decision, no misconduct, no chargeback, disaster.
The AT decision is correct. The claimant was discharged for failing to obtain a COVID-19 vaccination. The employer did not inform the claimant of the COVID vaccine requirement when she was initially hired. The employer then changed the employment agreement, introducing the new requirement for the employees to be vaccinated in order to continue working. The claimant's refusal to accept these substantial changes to her hiring agreement is not misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
I concur with Commissioner Esparza.
Short form dissent, ma'am.
Have your short form dissent.
Case 3574-506, Commissioner Esparza.
We should modify the AT decision. First, I don't contest the good cause issue concerning the job separation. Although the claimant was aware of the employer's reassignment policy, the claimant did not report until after the applicable time frame for reporting. Moreover, despite the claimant's assertion that she timely reported availability, the evidence shows that the claimant did not report until months after her separation from the client's company. Since the claimant was aware of the employer's rule on reporting, the claimant's failure to follow the employer's directives constituted voluntary separation without work-connected good cause. As such, we should modify the AT decision. Claimant established good cause for missing the AT hearing, voluntary leaving, no chargeback, sever adequate employer response.
The decision should be modified. I agree that the claimant established good cause for AT1 due to not receiving the hearing notice. However, regarding the job separation, the claimant testified that she contacted the employer in several ways upon being informed that her temporary assignment had ended, but that she was not offered any additional work. The employer only provided secondhand testimony that the claimant failed to contact the employer for further assignments. Therefore, the evidence established that the claimant complied with the requirement to make herself available for a new assignment. Since the claimant was not offered any further work upon making herself available, the claimant was discharged for lack of work and not due to misconduct. Modify the AT, claimant had good cause for AT1, no misconduct, chargeback, void adequate response.
Claimant established good cause for AT1, misconduct, no chargeback, adequate employer response.
So we have a majority vote on a disqualification, but not on the section of law. Commissioner Esparza, I believe you said voluntary leaving. And Chairman Daniel, you said misconduct. Is that correct?
Yes.
I'll concur with the chairman.
Okay, thank you.
Short form dissent, ma'am.
I have your short form dissent. Thank you.
Thank you.
Case 3584-363, Commissioner Trevino.
The AT decision is not supportable. The claimant consistently testified that he did not receive the AT1 decision at his address of record in a timely manner. Therefore, the claimant provided sufficient testimony to rebut the presumption of receipt. Since the claimant did not receive the AT1 decision, the claimant's petition to reopen should be deemed timely. Reverse the AT, deem timely the claimant's petition to reopen and resubmit.
We should affirm the AT decision. The claimant's Rule 16 petition was filed 1 day late. By providing inconsistent and contradictory testimony, the claimant failed to credibly and persuasively rebut the presumption of receipt. Accordingly, we should affirm the AT decision. The claimant filed a late Rule 16 petition to reopen, misconduct, no chargeback, adequate employer response.
Timely claimant petition to reopen, resubmit.
We will resubmit this.
Case 3591-628, Commissioner Esparza.
The AT decision should be reversed. The employer gave clear testimony that it did not receive the TWC document in question until after the appeal deadline had passed. The employer also testified that it checks mail every day and has complained about mail delivery issues in the past to no avail. Nothing in the employer's testimony on timeliness issue was inconsistent or contradictory. As such, the employer has given persuasive and credible testimony of non-receipt, and their petition to reopen should be deemed timely. Reverse the AT decision, timely employ Rule 16 petition to reopen, resubmit.
The AT decision is correct. The first AT decision was mailed to the employer's address of record on 6/16 of 23 and provided an appeal deadline of 6/30 of 23. The employer's response was not filed until 7/10 of 23. The employer's petition to reopen was late, and there is no good cause exceptions to the timeliness rules. Therefore, the commission does not have jurisdiction to consider the underlying merits due to the employer's late petition to reopen. Affirm the HE, late employer petition to reopen, no misconduct.
Timely petition to reopen, resubmit.
We will resubmit the case.
Case 3608-311, Commissioner Trevino.
The decision is not correct. The claimant was only 3 minutes late in registering for the AT1 hearing. She testified that she tried to register early for the hearing by phone, but that she was on hold for a significant time. When she realized that the hearing start time was approaching and she was still waiting on hold, she then started to register online. By the time she got registered online, it was 3 minutes too late. Since the claimant made a good faith effort to participate in the hearing, but was prevented from registering on time by circumstances beyond her control, she established good cause for missing the AT1, and the case should be resubmitted for merits testimony. Reverse the AT, claimant had good cause for AT1, resubmit.
The AT decision should be affirmed. The claimant's contention that she was prevented from attending the appeal hearing due to circumstances beyond her control is not supported by commission records. As such, the claimant did not have good cause for her non-appearance. As to the job separation, the claimant was fired for a violation of the employer's code of business conduct. Specifically, the claimant did not process a custom request. The claimant also had prior warnings for similar incidents. As such, the claimant's actions constituted work-connected good misconduct. We should therefore affirm the AT decision. The claimant did not have good cause for her non-appearance, misconduct, no chargeback.
Claim established good cause for AT1, resubmit.
We will resubmit the case.
Case 3612-638, Commissioner Esparza.
The AT decision should be affirmed. The claimant was discharged due to poor job performance. The employer testified that the claimant was not going on sales calls with bankers. The employer's documentary evidence also state that the claimant did not consistently visit the banking centers assigned to him, some of which he had not visited at all. Aside from stating that he was working to the best of his ability, the claimant did not provide specific testimony denying that he failed to visit some of the branches. Not taking action is different than taking action and not meeting the employer's expectations. Moreover, the claimant did not receive his first disciplinary notice until over 6 months from the time he began the job. Therefore, it is reasonable to conclude that the claimant had met the employer's expectations for some time. Accordingly, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
The AT decision should be reversed. The claimant was discharged for his failure to meet the employer's sales and production goals. However, the employer failed to establish that the claimant was ever consistently able to meet the employer's goals despite his best efforts. The claimant also provided evidence that the economic conditions made it impossible to meet the employer's expectations. Therefore, the claimant was discharged due to the inability to meet the employer's performance expectations and not for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Misconduct, no chargeback.
Short form dissent now.
I have your short form dissent.
Case 3613-216, Commissioner Esparza.
We should reverse the AT decision. As a home health provider, the claimant's previous assignment consisted of part-time hours with the male client. The new assignment offered part-time hours with the male client in the same work location and at the same rate of pay. The work was clearly suitable. However, the claimant refused to work because of personal reasons. Since the claimant had not shown good cause for rejecting the new assignment, We should reverse the AT decision. The claimant rejected an offer of suitable work.
The AT decision should be affirmed. The claimant was a provider for the employer, a home health care company, and was laid off from her position when her father, who was her client, passed away. In the days following her separation, while the claimant was still out of town arranging services for her father, the claimant was offered a new assignment with the employer, but the new assignment was only for 15 hours per week. This was approximately half the hours the claimant worked in her prior assignment. Since the claimant was arranging services for her father and has already been assessed on availability and eligibility for the time that she was out of town, and since the offer of work was for limited hours per week, the claimant should not be disqualified for refusing suitable work. Affirm the AT, suitable work, eligible.
Affirm the AT, no suitable work disqualification.
Short form dissent.
I have your short form dissent.
Case number 3625-817, Commissioner Trevino.
The AT decision is not supportable. The employer discharged the claimant for failing to meet its expectations regarding the job performance. The claimant performed his job to the best of his ability and was never able to consistently meet the employer's performance expectations. The claimant's inability to meet the employer's standards due to the technology issues is not misconduct connected with the work. Reverse the AT, no misconduct. In the alternative, as the claimant had various absences due to his medical condition, thereby affecting his productivity, I could agree that the claimant's discharge was caused by a medically verifiable illness. Modify the AT, no misconduct, MVI.
We should affirm the AT decision. Although the claimant blamed internet and equipment related concerns for his deficiencies, the claimant continued to show lackluster performance even after the employer remedied his concerns and provided warnings to improve performance. Since the claimant previously met the employer's standards, but thereafter demonstrated repeat instances of poor job performance, claimant's conduct entailed misconduct connected with the work. As such, we should affirm the AT decision, misconduct.
Misconduct.
Short form dissent, ma'am.
I have your short form dissent. That was the last case pulled on docket 26. You should have received the short form dissent list for docket 26.
I move we accept staff recommendations on remaining UI cases on docket 26.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 26.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in the UI short form dissent list for docket 26.
Motion passes with the exceptions noted.
All right, we will move on to docket 27.
Case number 3456440, Commissioner Trevino.
The decision is not correct. We previously voted to grant the claimant's petition to reopen and deem the claimant's appeal timely. As to the earnings adjustment overpayment, the claimant, a flight attendant, was temporarily laid off from April of 2020 to April of 2021 due to the pandemic. Although the claimant was not performing any work during this period, the employer issued payments to the claimant in January through March of 2021, some of which included PTO that the claimant accrued in 2019. Since these payments were not for any work performed by the claimant was not required to report these payments as wages on her claim certifications. Reverse the AT, claimant had good cause for AT1, timely claimant appeal, no earnings adjustment, void waiver. In the alternative, if these payments were subject to an earnings adjustment, the claimant was not at fault for creating the overpayment, as she was not performing any work to report on her claim certifications. Modify the AT, claimant had good cause for AT1, timely claimant appeal, recalculate earnings adjustment, and grant waiver.
The AT decision is not consistent with the other cases involving the employees of the named airline who were temporarily idle during the pandemic. In other similar cases, the payments were determined to have been something other than wages. Unfortunately, the prior hearings have not covered that issue, and so a rehearing should be held to obtain testimony from the claimant and, if possible, the employer regarding the nature of the payments.
Rehear.
We will rehear the case.
Case number 3510-736, Commissioner Esparza.
We should modify the AT decision. First, I don't contest the validity of the claim issue. Concerning the job separation, despite being on final warning, the claimant was separated when she did not make a timely bank deposit. Although the claimant was aware that making deposits were necessary and non-negotiable part of her work, the claimant did not complete the task and thereafter did not notify the employer about her failure. Since the claimant was aware of the employer's rule concerning bank deposits, her failure to follow the employer's guidelines constituted work-connected misconduct. As such, we should modify the AT decision. Valid claim, misconduct, no charge back, sever adequate employer response.
The decision is not correct. I agree that the claimant filed a valid claim. Regarding the work separation, the employer discharged the claimant for an alleged failure to follow procedures. The employer required members of management to make deposits to the bank as part of their job duties. The claimant and assistant manager testified on the day in question that she was under the impression she was not responsible for making deposits, and that other managers also forgot to make the deposits. The employer testified that a first offense for failing to make deposits was not cause for termination, and the employer had not previously warned the claimant for this issue. Therefore, the employer did not meet its burden of establishing that the claimant's actions rose to the level of misconduct connected with the work. Modify the AT, valid initial claim, no misconduct, chargeback, void adequate response.
Valid claim, no misconduct, chargeback, void adequate response.
Short form dissent.
Have your short form dissent.
Case number 353-8845, Commissioner Trevino.
The decision is not correct. We've previously voted to grant the claimant's petition to reopen and deem the claimant's appeal timely. As to the overpayment, the claimant, a flight attendant, was temporarily laid off from April of 2020 to April of 2021 due to the pandemic. Although the claimant was not performing any work during this period, the employer issued payments to the claimant in January through March of 2021, some of which included PTO that the claimant accrued in 2019. Since these payments were not for any work performed by the claimant was not required to report these payments as wages on her claim certification. Modify the AT, claimant had good cause for AT1, timely claimant appeal, no overpayment, void waiver. In the alternative, if these payments were subject to an earnings adjustment, the claimant was not at fault for creating the overpayment, as she was not performing any work to report on her claim certifications. Modify the AT, claimant had good cause for AT1, timely claimant appeal, recalculate overpayment, and grant waiver.
Just as in the companion case, the AT decision is not consistent with the other cases involving the employees of the named airline who were temporarily idle during the pandemic. In other similar cases, the payments were determined to have been something other than wages. Unfortunately, the prior hearings have not covered that issue, and so a rehearing should be held to obtain testimony from the claimant and, if possible, the employer regarding the nature of the payments. So, rehearing.
And establish good cause for AT1, timely claimant appeal, recalculate earnings adjustment, waiver denied.
Would you please repeat your vote, Mr. Chairman?
Claimant established good cause for AT1, timely claim appeal, recalculate earnings adjustment, waiver denied.
I'm going to concur with the chairman.
I'll have short form dissent, ma'am.
Thank you.
Case 3555884, Commissioner Sparza.
We should modify the AT decision. First, I don't contend with good cause finding. Concerning the job separation, the claimant was hired to work as a delivery driver for the employer's contractor / client. He was involved in a serious work-related accident, which resulted in extensive medical leave, workers' compensation benefits, and a period of light-duty work in accordance with his medical restrictions. Police report noted that the claimant was at fault for the accident, and the claimant testified that the judge found that he had made an unsafe turn. When the claimant was medically cleared, the employer submitted the claimant's information to the employer's contractor, but the claimant could not pass the certification requirements due to being at fault for the accident. Because the claimant's own action resulted in his failure to pass the required certification, the claimant was discharged for misconduct connected with the work. We should modify the AT decision. The claimant had good cause for his non-appearance, misconduct, no chargeback, sever adequate employee response.
The AT decision is not supportable. Regarding the good cause issue, the claimant clearly testified that he never received the AT1 hearing notice due to a fire at his residence. As for the job separation, the claimant was discharged after he was denied clearance to continue driving from one of the employer's parent companies after returning from medical leave. The claimant provided credible testimony that he had returned to working for his employer for several months before he was notified that he would not be reinstated as a delivery driver, and that his employer was already aware that would be not permitted to continue working as a delivery driver at the time that he returned to the job. Therefore, the employer failed to establish that the claimant's inability to obtain clearance to drive was misconduct connected with the work. Reverse the AT, claimant established good cause for AT1, no misconduct, chargeback, or adequate response.
Claimant established good cause for AT1, no misconduct, chargeback, void adequate response rule.
Short form dissent.
I have your short form dissent.
Case number 3620410, Commissioner Trevino.
AT decision is not correct. The claimant was discharged for allegedly failing to follow the employer's instructions regarding an unreasonable task that was assigned to him. The claimant provided credible and consistent testimony that he merely asked for clarification on the instructions provided to him, and he was denied, refusing to follow the employer's instructions. An employee asking reasonable questions to clarify instructions on how to perform an assignment task does not constitute insubordination, and the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should affirm the AT decision. The claimant was terminated for refusing to follow a direct order from the supervisor. Upon being advised to move the employer's tractor to a new location, the claimant became argumentative and refused to follow the employer's directives. Since the claimant was provided specific instructions, his refusal to follow the employer's directives constituted work-connected misconduct. As such, we should affirm the AT decision of misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
I have your short form dissent.
Case number 3622276, Commissioner Sparza.
The AT decision should be modified and decided under section 207044 of the Act. The claimant was fired after missing multiple days of work. Claimant's equipment broke down several days before being terminated. However, on the same day of the equipment breakdown, the claimant was notified by the employer via text that he needed to show up for a mandatory meeting the next day. The claimant responded that he was out of town and would not attend the meeting. The claimant had not told the employer he was going out of town. In the ensuing days, the claimant was asked twice about whether he was going to return to work, but the claimant did not return. Because the claimant did not show up to work and as required by the employer, he mismanaged his position of employment, which constitutes work-connected misconduct. Moreover, if the case is viewed under section 207045, the claimant should be disqualified because he left the job site without notifying the employer and did not return to the job site for the employer's available work due to personal reasons. To modify the AT decision, misconduct, no charge back. In the alternative, I could also agree to rehear the case to further develop the final incident and to get clear testimony from the claimant regarding what he was told about his job status the day his equipment broke down. So rehear.
The decision is not correct. After new ownership took over the company in March of 2023, the claimant was not given any work for the next several months. When the claimant was finally assigned to the project in late June, he worked for a brief period before equipment broke down and his crew was sent home from the job site. Due to the project shutting down and due to the lack of work over the prior few months, the claimant reasonably believed that no further work would be available for some time. Therefore, the claimant traveled out of town to visit family. The employer then contacted the claimant to see if he could work a small project in early July. However, the claimant informed the employer that he was out of town and that he would be returning the next week. The employer then discharged the claimant. Therefore, if this separation is viewed as a quit, the claimant had good cause connected with the work to leave the job due to the extreme decrease in available work over the last several months. Reverse the AT, no voluntary leaving, chargeback. In the alternative, if this separation is viewed as a discharge, we should reverse the AT, no misconduct, chargeback, as the claimant was discharged due to lack of consistent work.
Voluntary leaving, no charge.
The chairman has,
I agree with the
voted
chairman.
to disqualify the claimant under 207045 voluntary leaving. And, Commissioner Sparta, I believe, disqualify the claimant under 207044 misconduct.
I agree with the chairman.
Thank you.
Short form dissent, ma'am.
I have your short form dissent.
Case number 3637-357, Commissioner Trevino.
The AT decision is not supportable. The claimant provided consistent firsthand testimony that he was scheduled to begin work with the employer on 7/25 of 23. The claimant reported for work that day, and worked the entire day, and then was discharged because the employer alleged that the claimant was supposed to begin work on 7/23 of 23 and had been a no-call, no-show for 2 days. Since the employer failed to establish that the claimant was aware that he was supposed to begin work on 7/23 of 23, the claimant was discharged for reasons other than misconduct connected with the work. Additionally, the claimant would have been qualified to receive benefits if he had never reported to work on 7/25 of 23, as this job was not considered suitable work for the claimant, and the claimant was receiving benefits when he took the job. And it paid much less than his maximum wage demand, so disqualification in this case is not appropriate. Reverse the AT, no misconduct, no overpayment.
We should affirm the AT decision. The claimant was discharged for being absent without notice his first 2 days of work. The claimant's testimony is neither credible nor persuasive, as it is contradicted by his own witness and text messages he submitted on his own behalf. Furthermore, section 207045G1 of the Act does not apply since the claimant did not voluntarily leave his job. Accordingly, we should affirm the AT decision, misconduct, overpayment.
Misconduct, overpayment.
Short form dissent, ma'am.
I have your short form dissent. That was the last poll case for docket 27. You should have received the short form dissent list for docket 27.
Move we accept staff recommendations on remaining UI cases on docket 27.
I second the motion, except for those cases in which I am dissenting, as reflected on UI short form dissent list for docket 27.
I concur with the chairman's motion, except for the cases on which I am dissenting is reflected in the UI short form dissent list for docket 27.
Motion passes with the exception noted. Brings us to the end of agenda item 8. Let's pause for a few minutes.
Thank you.
A little bit. Get it back down. Oh, no. I told him.
Tommy thought we meant we're working out right now. We're going to the gym right now. You,
Y'all wanna work out, I'll work
you,
out.
you got him all
Yeah.
ready to go and we still got meeting to do.
Easy.
I think Tommy does like martial arts and stuff over there.
Yeah, I think,
Maybe some UFC, I don't know.
is it DPS, Tommy?
Yeah, he works at it.
Is that the DPS workouts?
Yeah, I don't know if it's mixed martial arts or
Yeah.
ultimate fighting championship, but it's one of the two. I see him when he comes back from his workout
Yeah.
sometimes, just saying.
It's like ninja blood or something.
So, you know,
No.
I don't know, when Conor McGregor's probably rehabbed by now, they could probably. It'd be like a main card right
Yeah.
there,
Tyson almost came out of retirement.
you know? I guess
The Tommy. Yeah, I don't know. Didn't happen. I don't know.
probably Tommy versus Jake Paul coming up. pretty soon.
Tommy the gun. Is that already taken?
All right, Tommy's had enough attention, I think. He's ready to go.
Go on.
This is agenda item 9, proposed amendments to 40 Tech Chapter 800, General Administration to conform WIOA and repeal Project Rio.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Sarna. For the record, I'm Shirley Jones with the Workforce Development Division. Commissioners, before you today, for your consideration for approval are proposed rule amendments to Chapter 800, Subchapter B. These proposed amendments will affect Chapter 800, Subchapter B to align with current federal program requirements, primarily those relating to the Workforce Innovation and Opportunity Act. The proposed rule also removes references to Project Rio, including the removal of Section 800.65 in its entirety. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period. Staff also requests the ability to make minor, non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation, and I'm happy to answer any questions you may have.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move we approve the proposal of amendments to 40 Texas Administrative Code, Chapter 800, General Administration for publication in the Texas Register and public comment as recommended today by staff.
A second.
It's been moved and seconded, motion carries. This is agenda item 10, additional funding for fiscal year 2025, Chapter 133 Apprenticeship Training Program.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Cerna. For the record, Carrie Ballast, Workforce Development Division. At its June 18th meeting, staff were asked to bring back a discussion paper detailing funding to be used to supplement Texas Education Code, Chapter 133, Apprenticeship Training Program funding for fiscal year 2025. The discussion paper in your notebook materials lists the funding and amounts staff have identified and recommend. This concludes my remarks. I'm happy to answer any questions.
Any comments or questions?
None here.
One question or one direction here. I do support the staff proposals. for the amounts, except for pulling, and I want to identify the $1 million from the TIRA grant program. I feel like that 1 million was dedicated from the legislature for that purpose, and I want to avoid moving those funds into supporting of U.S. Department of Labor registered apprenticeships. And so respectfully, if we were able to basically sever the 1 million from TIRA, I'd be happy to support the rest of the staff proposal. Thank you.
I tell you what, I'm gonna vote for this, but in deference to Commissioner Sparza. I wonder if we can vote everything but the TIRA funds, but not remove it entirely, and let staff go back and prepare some materials describing why we should, why we shouldn't, why we could, why we couldn't. I think budget wise, we can technically. We're not gonna get in a trap in the next couple of weeks in terms of needing more money to get to the $4 rate. So I guess my preference here would be to just vote this out minus the TIRA funds, with the understanding that staff will come back here in a week or two and give us a rundown on those TIRA funds and why they think that would work, and just give us some more rationale. At that time, Commissioner, if you still don't like it, we can look at other options, but I don't actually have a problem with it based on my understanding of the structure of the funds, but I think you raise a good point. It probably deserves some attention.
Thanks, Chairman.
Okay.
Is that good for you, Commissioner?
Yeah, and if I could just ask if Mr. Nelson could look into that and how that established. And
Yeah.
what the rationale was, I could agree for that too. So we're gonna do my motion, I'll just read it and then it'll be what that is. Okay.
Before you do that, I also want to make sure that I've got a good idea of how much of the TIRA program that, I know it's a new program. I know we're taking applications in on it. I just want to make sure that we're not already using that money for something else before it was intended to that. So please give me kind of an idea about where that program is and what application processes we have involved with it. You
We
wouldn't
can
mind?
do that. Yes, sir.
Didn't mean to cut you off, Chair.
That's fine.
Commissioner.
That's okay. Yes.
Commissioner.
Yeah.
So your motion,
Chairman, I move that we approve the addition of the $2,088,527 in fiscal year 2025, chapter 133 apprenticeship training program funding as described in the discussion paper and presented today by staff.
all right, and go ahead.
Go ahead, Chairman. I would ask to amend that amount to 1 million. To remove the 1 million of TIRA, not the full 2.08.
Let's do it this way. I second the motion. I move to amend the motion by striking $2,088,527 and putting $1,088,527 with the understanding that the $1 million from the Texas Industry Recognized Apprenticeship Grant Program will come back for discussion on this item in 2 weeks or at our next regular schedule meeting, because I don't know when the next one's scheduled. Commissioner, is that?
Yeah, that's fine with me.
That's
Thank you.
accurate. Yes, sir. Thank you,
All
Chairman.
right, no objection to the amendment. That's the amended motion. Are there any objections to the motion as amended?
None here.
All right, we're gonna bring this back for a discussion. Come back and talk to us about TIRA. I'm giving you 2 weeks so you can talk to us during the 2 weeks as well. Just make sure all the questions are on the table.
Okay.
And then depending on the nature of that, you're also gonna want to be thinking about what would be a substitute for the TIRA money if in fact we find some reason why we shouldn't or couldn't do that. All right,
Yes, sir. Yes, sir.
everybody satisfied?
Yes.
Yeah, we're moving the ball down the road to address the contact hour rate. We just have to come back and address this last $1 million. All right. Thank you.
Thanks.
So agenda item 11, advisory board recommendations regarding fiscal year 2024 jet grant awards.
Morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, Mr. Serna. For the record, Matt Snidecki, Program Manager for the Jobs and Education for Texans Grant Program, Workforce Development Division. The FY 2024 Jobs and Education for Texans Grant Request for Application was issued on March 29th, 2024 for grant awards to public junior colleges, technical institutes, state colleges, open enrollment charter schools, and school districts. TWC was allocated approximately $15 million for FY 2024. On June 20th, 2024, the advisory board met and made the following recommendations to the commission regarding 2024 JET awards: to direct staff to move forward with awarding grants based on final evaluation score with ability to move down the list 55 points and above should additional funds become available during the contracting phase. Staff seeks direction regarding the JET awards for 2024 as recommended by the advisory board. I'm happy to answer any questions.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move we approve the Jobs and Education for Texans Grant Awards for fiscal year 2024 as recommended by the JET Advisory Board and in conformity with the final evaluation scoring, and allow staff the ability to move down the list of applicants scoring 55 points and above as funds become available during the contracting phase.
I second.
It's been moved second, motion carries. It's agenda item 12, advisory board recommendations concerning FY 25 JET program funding and parameters.
Chairman, Commissioners, Mr. Cerna, again, Matt Snidecki, Program Manager for the Jobs and Education for Texans Program. The TWC anticipates being allocated approximately $15 million for FY 2025. Again, on June 20th, 2024, the JET Advisory Board met to discuss program parameters and funding allocation for FY 25 and made the following recommendations. The first is funding allocation to be split 35%, 65%, 35% for institutes of higher education, 65% open enrollment charter schools and school districts. The second is minimum and maximum grant amounts, minimum being $40,000, maximum being $375,000. The third is the number of applications per eligible applicant that will remain at one application per eligible applicant. And number four is the minimum score threshold for award eligibility. And we recommend utilizing a 60% score of total points available. Staff seeks direction regarding the adoption and implementation of program parameters for FY 25 as recommended by the JET Advisory Board.
Comments or questions?
None here.
No question.
Is there a motion?
Chairman, I move we adopt the Jobs and Education for Texans program parameters for fiscal year 2025 as recommended by the JET Advisory Board and described in the discussion paper presented today by staff.
I second.
Been moved second, motion carries. Is there an executive director's report to the?
I actually have some things to
All
report to you
right.
on today, very quickly. First off, I want to make sure that the commission knows that our new child care case management system was implemented this past weekend. That's Tech C3. We've had extensive trainings with the boards and they were involved in user acceptance testing. They will continue to enter childcare information into the old system, TWIST, but can also enter it into the new system so they become familiar with the new system before before that's the system of record on September 1st. But it is up and running and it has several other features that are available to our customers as well as our own staff and the board staff. So we're very pleased with that success. Second, I want to recognize our appellate services staff. Some of the staff attended, and I didn't realize this organization existed, the National Association of UI Appeals Programs. Just in case you were wondering.
It sounds like a pretty rowdy meeting.
It probably was, yeah, a lot of lawyers and stuff. But we were recognized for a practice of ours that our staff came up with to deal with the high volume of one-party cases. It's basically a rotating ineligibility docket where we double schedule cases and can move through the cases faster. This was recognized as a best practice and advocated for the association members recognized it and said other states could use the same practice to get rid of their backlog. So that was kind of encouraging. And then finally, in sort of a left-handed compliment from Department of Labor, our staff, because of our expertise in dealing with disasters, hurricanes, fires, floods, that kind of stuff, the Department of Labor is going to set up a meeting with us to meet with our New Mexico counterparts. They have less experience dealing with disasters, but have recently had several disasters over there, and will help them on how to handle the disasters as they affect their UI system. So there's some left-handed recognition there, left-handed in the sense that I would prefer that we not be good at dealing with disaster, not have disasters to deal with, but if we have them, I'm glad that we're good at dealing with them and recognized for such. And that's all I have to report.
All right, any other order of business come before the commission?
None here.
No, sir.
Is there a motion to adjourn?
Chairman, I move to adjourn.
I second, Chairman.
Moved and seconded to adjourn, and we're adjourned.